Your Honor, Ron Atanasio from the Knoxville Bar here for the
Yes, sir.
appellees. I initially filed the motion based on the deed that was filed in the registrar's office. It appears there's a second part of the deed based on the response, so obviously most of the arguments that related to that would be moot, if you will.
Okay.
Therefore, it in essence should be withdrawn.
Okay, well, we'll treat the motion as being withdrawn then. Thank you. That's what we were thinking, perhaps. Now we'll hear from the appellant.
Okay. Your Honor, may it please the court, my name is Brian Quist here in Knoxville, along with my law partner, Brian Sableman. We represent the appellants, Waterfront Investments and Villages HOA, the homeowners association that is now called Clearwater Cove. I'd like to reserve 3 minutes for rebuttal, if I may.
That'll be fine.
Okay, so today I have a brief introduction to the case. I will then recap what I think to be the issue, followed by a discussion of the proof at trial. Okay, so this is the case where a reservation of ownership was made on a plat map, which was then incorporated by reference into some deeds for the shoreline lots at a lakefront development on Norris Lake in Campbell County, having about 400 lots. Most of the lots are interior lots. So this case concerns construing deeds. More specifically, the shoreline lots at the development received less than a full lot. What was reserved by the original developer was ownership of a 1-foot wide strip of land called a buffer down towards the shoreline of each lot. Now, because we know the proof at trial that for a marina operator to get a TVA permit, the marina operator must own or control the shoreline where the harbor zone of the marina is to be. It makes sense why the owners of the shoreline lots received less than a full lot and that the original developer retained something. We also know from the proof at trial that for a lakefront community to be successful, opportunity for an adequately sized marina must exist. So, though I'm not a boat person, I understand it to be quite a thing that to live near the water, walk out of one's door, get in your golf cart and go down to the marina, and then walk out to your boat slip, and then off you go for a day of boating. So bear in mind, this development had 400 lots. Most of them are on the interior, so having a marina adequately sized is it's really important. So once we know these facts, the pieces fall together, and when defendants bought their lots, none of them saw the plat map, and so they didn't know the buffer reservation was on their lots. At least two of the defendants applied to TVA for private boat dock permits. So applying for a private boat dock permit on the shoreline conflicts with shoreline control by the marina operator for it to have its harbor zone. So that's why we're having this lawsuit, Your Honors. With the remaining defendants, incidentally, the shoreline control issue has been resolved with all the other shoreline lots encompassing the projected expanded marina harbor zone, including recently the Lisa Collins Trust, which took place after trial. So here's the legal issue. So here's what I think the legal issue is for this case. And I think it's interesting. And what I'd like to do is for the court to perhaps affirm what I perceive to be the differences in the methodology when it comes to deed construction versus contract interpretation. So in contract interpretation, we do concern ourselves with the intent of both parties, and whether there's been a meeting of the minds. In contract interpretation, clarity of intent in the document itself is very important. And rules for explaining ambiguities in contracts are rigid. In contract, language that is hopelessly vague or ambiguous can be disregarded because the result means, in fact, no meeting of the minds. A deed, on the other hand, is typically performance of a contract. And the case law tells us the mission, frankly, I think, is to just construe the grantor's intent. Case law further guides us as to being permitted to find the grantor's intent from evidence external to the contract itself. In my brief on page 23, I cite from the Eastern Section Court of Appeals the case of Ottinger versus Stooksbury. And in that case, it provides a pretty good example of the process and the methodology for construing a grantor's intent if you need to. Now, apparently the need to construe intent arises from the grantor's use of the word buffer. But anyway, in the Ottinger case, I was pleased to see that the court is allowed to do what you might expect, which is to look at all the surrounding evidence. And in that case, the Court of Appeals looked to such things as building plans, alternative costs, conduct of others, other improvements, payment of taxes, all of it to get together to say, this is what we think to be the grantor's intent. So, thus, in deeds, when language is less than precise, the result is not the stopping point. That is not the stopping point. If the language is less than precise, you can go further and you can construe the grantor's intent. And frankly, I think there is actually a very high bar to meet when it comes to just ignoring a provision in this deed, which is what the defendants have suggested. You can just ignore it. That is, to be rendered unenforceable, the provision in the deed must fail for complete indefiniteness. And on page 28 of my brief, I cite the Mitchell v. Chance case that explains what that is. Complete indefiniteness is when there's absolutely no discovery of facts possible, nothing that would ever shed light on why did the grantor put that in there? Why? And that there's absolutely no set of facts. Well, in this case, we have plenty of facts. We have plenty of facts for such discovery to restore any doubt of these words. In this case, it appears the trial court did not construe the grantor's intent. The trial court just stopped at the word buffer, finding it to be vague and ambiguous. So our position is that the trial court erred by just stopping there. Instead, the ample proof at trial as to why that language was there and the mission it accomplishes by having the original developer retain shoreline control for a marina harbor zone is pretty compelling. And that's all discussed in great detail in my brief. Our proof discussed beginning on page 23 of my brief was that the grantor's development plan called for a marina. We had trial exhibits that showed that. Shoreline control was needed for a marina permit. I had the marina operator, Mr. Potter, testify. He knows all about it. He owns several marinas. He talked about the TV regulations. Basically, you have to own or control the shoreline to get your permit. Waterfront even paid taxes on the buffer for some period of time until the county decided to inexplicably say that was TVA land, which that's neither here nor there.
Did the developer tell the county they were wrong?
Well, it's kind of like tax maps. tax maps are useful, but they're really not controlling.
I know, I'm just curious whether your client told the county you're wrong, we should still be paying taxes on this property.
We haven't got to that point yet because that came to my attention right before the trial.
Okay.
All right, so in this case, the original developer used the word buffer, and I resist the idea that we're all mystified by that term. You can say, I convey to you a 1 foot wide strip of land. Well, what's a strip? I convey to you a 1 foot wide portion, a 1 foot wide swath, a 1 foot wide buffer. So buffer, I think, is a very acceptable term, especially when you understand the symbolic reason for controlling the shoreline. And at minimum, I think buffer means don't build there. Don't build your boat dock because we got to have our harbor zone. And incidentally, these shoreline lot owners, they can have boat docks, they just got to go through the marina.
I had a question about that.
Yes.
When you say that, do you mean that they can build their own private boat dock
And-
with permission from the marina,
And-
not just rent a slip from the marina, that the slips that are built by the marina?
Yeah, correct. Depending upon what your boat dock is going to look like and how big it is, you go through the marina and pay an annual fee, which is different than the one-time fee to TVA. Because the TVA wants the marina operator to control the harbor. The marina operator is pleased to allow people to have floating cabins in the harbor zone, which is a different animal.
Well, and assuming that the marina approves the building, I mean, I guess my question is, why would, if the marina's goal is to expand the marina and it needs the land on the shoreline where these property owners' land abuts, why would they ever grant these individual property owners a private dock? It's inconsistent with wanting to expand the marina down the shoreline.
They don't necessarily conflict. There can be enough space for everyone. The point is TVA wants to look to one entity, which is the marina owner, to say, this is your harbor zone. You can kind of do some things that you like have a floating cabin, which is a completely different animal. So yes, it can be done. In the time provided, the second part of my brief had to do with hearsay objections. Well, for what sales representatives of the original grantor may have said, so those admissions were incorrectly admitted, but I'm not.
Why were they incorrect to admit them?
Well, because they're not admissible hearsay. They're statements by sales representatives of the original developer, and for that to come in as a party admission, you got to prove a lot of things, like authority of the sales representative to waive this buffer requirement. And I think that's why that proof was
What was
introduced.
your argument at trial on this? What did you tell the trial court?
Well, first I said they're inadmissible hearsay, and that the argument was those sales agents, those salesmen of the original developer are not our agents because my client bought assets in a bankruptcy. We bought assets in a bankruptcy. Those folks are not our agents. That was my initial argument. And authority for these agents to have waived something, that authority had to come from the principal, not just by what some agent may have said. But the reason for my putting that all in the brief is I don't think those statements should be considered by this court. I think I've kind of covered everything.
You've used your time, counsel. You got your time for rebuttal.
Sure. Thank you.
Thank you. We'll hear from the appellee.
Make Again, may it please the court, Ron Atanasio here for the appellees, or certain of the appellees. Two matters are not at issue. The grantor, successor, the plaintiff, Waterfront Investment, past, present, and or in the future, has no obligation whatsoever initially to build the marina, but to expand the size of the marina. There's no obligation on their part. And in fact, at the time of trial, there were 48 slips, even though it was permitted for 140 slips. But there's no obligation and there's no issue with that. The second is that the grantee defendants' intent was to purchase dockable lots, the right to have a private boat dock, and the plaintiffs so admitted in the trial court that the intent was there and that this allegedly hearsay evidence could go to the intent of the purchasers but not to the intent of the grantor. To answer the court's question as to having your cake and eating it too, while one can have a private dock in a harbor zone, it's at the pure discretion of the owner. And so if the owner says, we no longer want you to have your private dock, it's gone. So it isn't like we can have everything in this case. The plaintiff's position, as I understand it in this case, is that the buffer note, the grantor's intent was to protect or control the harbor zone. The fatal flaw with that argument is that this buffer note attached to all lots adjoining Norris Lake, not just those inside the harbor zone, but to all lots adjoining Norris Lake. If such was the intent, it would have been easy enough to restrict the boat docks, this buffer, to only those inside the harbor zone. In this case, the grantor in the plats knew how to reserve an interest in real property. Examples being drainage easements, lake access, both of which were clearly and expressly reserved within the plats. So if the intent was to protect or restrict the harbor zone, it would have been easy enough to do that just as to those particular lots.
Was there, going back to what you said a minute ago, was there proof presented as to how many lakefront lots outside the harbor zone had this buffer restriction?
It did, Your Honor, and there was proof that was presented. And what happened was, I think a motion was filed in the trial court for failure to join indispensable parties, meaning those others who were subject to this buffer. And then there was, on the part of Waterfront, the present grantor developer, they ended up deeding to those property owners outside the alleged harbor zone. They deeded the 1 foot buffer to those landowners. So yes, sir.
And this is all in the record?
Yes, sir,
Okay.
It is.
All right.
Plaintiff's own expert in this case testified that to reserve a fee simple interest, and that's what the plaintiffs are claiming, they own a fee simple interest in the defendant's lots due to this 1 foot buffer. It requires specificity. To whom? For what? A discernible description, all of which were admittedly not present in this case. As to an easement, the same restriction or same requirements. Again, admitted absence of those requirements. The plaintiffs did not prove, and the court so held, that the buffer note failed to reserve or retain a fee simple interest, an easement, a restrictive covenant, or any other interest in property of the defendants. They simply failed to prove that, and the court so held. So to say that it's been established that we have an ownership right in these lots, and what does it mean? That's just simply not true. You've got to prove you have an ownership interest. And they failed to do that. The plaintiffs did. And the court so held.
Well, what did, I understand the trial court found that it was ambiguous, but if there's no fee simple, no fee interest, no easement, what did the grantor mean with, say, using buffer?
Good question. And I think what the court tried to do was to determine what they meant.
And did the trial court end up giving it, in effect, no meaning?
The trial court, in effect, said it was insufficient to create an interest in the property that would prevent the property owners from having their own dock. Okay?
So there's something there, we don't know what it is, but we know it's not a hindrance to the owners and their ability to build their own dock.
Correct. And again, because the language used, and we say, well, you can't use buffer, you can't use something else, it's a guess. Okay? And as to, well, it was meant for this purpose. Under the facts and looking at the plat, there was language where it was clear that the entirety of the lot was transferred to the defendants. The pins, it went to the 1044 contour. And I think counsel did a good job in defining what the contour is, and we have a number of TVA lakes in this area, but it's the point to where it would overflow the dam, the 1044. And the language in the plat was that the lot owners, in this case the defendants, they owned to the 1044. The pins were at the 1044. So it wasn't as if the court just ignored it, Your Honor. The court basically said in order for you to restrict the fee to these folks on their lake lots, you have to have the definiteness. You have to have these other items. Otherwise, it's ineffective. So it wasn't that it was nothing or non-consequential. You just didn't do it. If that's what you were trying to do, it wasn't accomplished. And in fact, the plaintiff's complaint in this case, Your Honor, construe a relief requested, construe deed to determine intent of the parties, and a ruling that the plaintiff reserved by way of a buffer note a fee simple interest in defendants' lots. That was the relief that was requested. And the trial court simply ruled that the plaintiffs did not so reserve or retain such an interest. From the record, it's clear the court determined the intent of the parties and the intent of the grantor from the surrounding circumstances, including but not limited to testimony of the plaintiff's, Waterfront Investments general partner, sales literature of the grantor, TVA writings and regulations, testimony of witnesses for the parties, testimony of experts for the parties, conduct of the parties. In addition, the court applied the general rules of construction. And as a result, the trial court used the proper standard in construing the deed and the rights of the parties thereunder. Because again, what we were dealing with here, Your Honor, are two competing deck actions, one from the defendants and one from the plaintiff. As to the allegations, the hearsay issues.
Let me, before you leave that, make sure I understand. Sure. You're saying that the deeds to these individual defendants, the deeds to them describe the property that was conveyed to them being bounded as to on the probably 1044 shoreline, meandering with that?
Exactly, Your Honor.
That was in the description of the property conveyed.
In between where this little buffer shows up in the plat, and it's in the record, Your Honor, on the plat it specifically says just that it meanders with the 1044.
What does the deed say?
The deed incorporates the plat. In other words,
does it give a property description that says it goes
correct
to the 1044? And
plaintiff's own expert testified that that is common practice in Campbell County and a number of other counties where you refer to the plat for the description. And it was not only said it once, the shoreline boundaries of any lakefront lots shown hereon meander with the 1044 elevation contour of Norse Lake. It goes on, it says, there are iron pins at all lot corners unless noted otherwise. and the iron pins were to the 1044, not to the 1045, but to the 1044, went all the way to the 1044 contour. That was in the deed, Your Honor. That was part of the deed. As to the hearsay issues, grantor's real estate agents, arguably the only proof in this case as to the grantor's intent, agents of the grantors. They concerned emails and direct representations to the defendants that the lots were dockable. Initially, the plaintiffs argued at trial that they were not agents of the plaintiff Waterfront Investment. On appeal, it appears it's shifted to it's not against the agent's interest, the declarant's interest. Therefore, it does not fall within the hearsay exception. The defendant's response to that was, well, that was not properly raised in the trial court, and it shouldn't be heard here, at least as to the declarant's interest. But if you don't agree with that, if the private docks affect the ability to sell interior lots, which is the plaintiff's position, then it would be against the pecuniary interest of sales agents if the lots weren't sold. Respectfully, from the record, it's clear the trial court acted properly in all respects.
What did the proof show as to what the plaintiff here, what it bought at the bankruptcy from the, as I understand, they purchased it from something from the original developer's bankruptcy?
Well, and that part of that's at issue, Your Honor, because I think in terms of the proof showed that they bought either lots and or the marina property. It wasn't that there was no discussion between the grantor, the original grantor.
All right, my question is, did they purchase just assets of the debtor, or did they purchase the rights of the debtor and as a developer?
I think they purchased assets, and in the defendant's expert went on to say that as they only purchased those assets, that they didn't purchase the rights to the buffer.
If they only purchased the assets, how are the statements of the sellers who were agents of the original developer, how do you get it in as a party admission if all they purchased was assets, not the developer's rights?
The plaintiffs allege that they are successor interests to the buffer. In other words, they say, yeah, we purchased assets. They want to have their cake and eat it too. We purchased assets, but we also have the right to the buffer.
Well, they claim that's part of the assets they purchased.
They claim it is, Your Honor. But if we're trying to determine what the intent of the grantor was, it isn't Waterfront Investments who was the grantor in this case. It was the original developer. And those agents are the only ones who really spoke for the developer. The grantor in this deed, the grantor is not Waterfront. The grantor is the original. Thank you very much.
Thank you. Here from the appellant rebuttal.
Your Honor, just briefly hitting on some points made by opposing counsel. The first point he raised was the no obligation to expand the marina point. In my reply brief, I addressed that by saying, yes, you can have a right without an obligation. The best example is an option contract. So I think that's a little bit of a non-starter. I think the court may have raised this as well. I went to trial to prove what I thought was the best probable, most likely meaning of why that language was there. And I thought it was pretty good as to why that's there, because once you understand the need to control the shoreline, it really clicks. So that's my suggested meaning of grantor's intent. They didn't suggest a meaning, an alternate meaning about, well, what could it mean? They just said, oh, it's vague and the word buffer's mysterious. In terms of real property conveyance, you can convey a tract of land. I give you Blackacre, less and accept something. That makes sense. So these lot owners, they got their lots less and accept the buffer that was reserved.
Or did the property description go to the 1040, of the land conveyed, go to the 1044 line?
Yes, that says this is your lot. It goes down to the 1044, and then, but reserved from that,
I understand.
less and accept. Yes.
Are you saying that it was your position, your client had a fee simple in that 1 foot?
Yes, because my, based upon the analysis of my expert witness, that's the default provision in his view, that it's not an easement because it doesn't describe the dominant estate, the subservient estate. So to say reserved is a 1 foot wide buffer, the best view is that, yes, that's fee simple. We reserved ownership of that. My final point is that the court had a question about what Waterfront's predecessor bought at the bankruptcy sale. That's in Exhibit 5. Trial Exhibit 5 is kind of a book of information where I had my title attorney go from beginning to end. This is how and why Waterfront owns the buffer. I think I've covered everything with time to spare. Thank you, Your Honors.
Thank you. Of course, thanks to counsel for both sides. We appreciate your arguments today and your briefs on this.